we'll go ahead and get started. Other people can come in. They'll mostly miss Elizabeth's introduction, but that will be all right. Before we started, I wanted to say that we have arrayed back here a number of pots. Those are not merely decorative. Those are gifts for those of you who have spoken to us today. They're all wrapped up with your names on it, and we are going to ship them to you. We are not going to expect you to put delicate pots in your suitcases and take them back on the airplane. But we very much appreciate the participation of the speakers here today. For the first two speakers after lunch, we have, in essence, a couple of sort of case studies, I guess, looking at more specific instances. And our first speaker is Elizabeth Kronk, and Elizabeth is going to talk about, if I've got this right, sort of the comparison between the Kivalina case out of Alaska and her experiences in China with respect to climate change. And Elizabeth is an assistant professor at the University of Montana Law School, where she specializes in environmental and Indian law. She has taught as well at a university in China, which I will not attempt to pronounce, as well as spending a significant part of this last summer in China, working with the U.S.-China Partnership for Environmental Law. So part of the summer in China, part of the summer here, and that's going to form, I think, part of the basis of what she's going to talk to us about today. She is a citizen of the Sault Ste. Marie tribe of Chippewa Indians in Michigan and serves as the chief judge of their appellate court. She practiced environmental Indian and energy law in Washington, D.C. with Latham and Watkins and Troutman Sanders, served as president of the D.C. Native American Bar Association. She currently serves as chair of the Fed Bar Indian Law Section and received their Outstanding Service Award this year. Also serves on the board of Michigan Indian Legal Services and the Missoula, Montana YWCA. She has a bachelor's in communication from Columbia, a law degree from the University of Michigan Law School. Please join me in welcoming Elizabeth Kronk.
Thank you, Judy, and thank you to everyone. I just want to start my presentation by really extending my heartfelt gratitude for being invited to talk on this timely subject. As we heard from Walter earlier today and all of our speakers this morning, it really is an important and interesting topic for us to be broaching, so I appreciate being here. A big thank you to the Native American Law Center, to Professor Royster, to Professor Rice, to Professor Lemus, and also a huge thank you to Leslie Scruggs and Babette, who assisted with putting this together. It literally would not have come together without their diligence. It's such an honor for me to speak with an esteemed group. I was talking to Professor Sosi before our panel today, and I said, can I go first? Because you're so amazing. I don't know if I want to follow you, because she's truly fabulous. So I just feel honored to be even included with this panoply of stars. And along those lines, if you have any questions as I'm talking today, I would be more than welcome, or I welcome your questions and conversations as I'm proceeding along. So certainly don't feel like you have to wait until I'm done talking to raise any questions that you might have. I really am excited to begin our afternoon session because I thought Julian did a wonderful job, Julian Berger, at the end of his presentation, of really setting up our discussion for the afternoon. When he said, how do we take the Declaration and make it work at home? And so I'd like to start looking at that conversation by really doing a comparative analysis, stepping out of the international arena for a while, and doing a comparative analysis between two Indigenous communities. One Indigenous community that I had the pleasure of working with in China this summer, and then also an Indigenous community here, the Kivalina village in Alaska, and looking at the claims that the two communities are relying on based on the domestic law of their countries, and then also making some suggestions for how possibly we could incorporate the principles of the Declaration, especially into the native village of Kivalina's claim here in the United States. So by way of overview, I'm going to give a brief introduction to Chinese environmental law, and then I'll look at the case study of a Tibetan village, which is north of Pingwu, where I worked this summer, as Professor Royster mentioned, and then we'll go into the case study of the Kivalina litigation and specifically looking at the claims there and how they could incorporate the claims from the Declaration. All right, so brief overview of Chinese environmental law. And the reason I wanted to present this overview is one of the things I was struck by this summer, spending my time in China. I've been there before. This is my third trip to China, is I didn't understand the extent to which environmental law existed and was really pervasive at the national level of China. So going back to 1983, China really had its first declaration with regards to environmental policy and passed what was its equivalent of an Environmental Policy Act, or our NEPA, in 1983. So China does have a fairly lengthy 20-plus year experience with environmental law, which was a bit of a surprise for me, because what I hear here in the United States is how China has massive environmental problems. So they do have some environmental laws that have been in place for a while, and the People's Republic of China created their National Environmental Protection Agency in 1988. They're really working towards sustainability. I heard that again and again in my time in China this summer. Is the goal was sustainability and harmonizing the human environment with the natural environment. So that goes back to their first policy statement in 1994. And also I wanted to point out in 1996, we got this first concept of a 5-year policy. And we'll see that again. I'm going to briefly go over the steps that the country has taken with regards to climate change, where every 5 years, the People's Congress, which is the highest level of government, so the Premier Wen, serves at the sufferance of the People's Congress. So when I have the People's Congress up there, that's really the highest level of government taking an action. So their government structure is a little bit different than ours here in the United States. But the People's Congress in 1996 made their first 5-year commitment to environmental review. And they're still doing that on a regular basis, and they're still now doing that in terms of climate change as well. One thing that's important to note here, and I bolded it at the bottom, that's different from the United States, is that the People's Republic of China owns the land in China. So anytime you're talking about environmental protection or land management or land rights, the government's going to play a very important role in that development, and the national government in particular. So that was an important factor that's going to play a role later when we talk about steps and solutions that the Tibetan village, the indigenous community that I worked with this summer, took in addressing climate change that I was not aware of previous this summer. Now, I did hear some mentionings that some rural indigenous communities own their land in communal ownership, but when I tried to follow that up and get specific examples of where are these communities, what communities are you speaking to, there was some confusion on that. So I did get some indication this summer that perhaps some rural land was owned by communities, but I can't give you specific examples of that. So there may be a caveat, but in general, the PRC, the national government, owns the land. So they're an important player. Now let's talk about Chinese developments related to climate change, because this is an important backdrop as well, because again, when I first went to China, I always heard, especially coming out of Copenhagen, that the People's Republic of China was evil in their negotiations from Copenhagen. Just to summarize it, be a little flippant, but not positive in their developments with regards to climate change. So I was really quite surprised this summer to discover that in some ways China has been more progressive. You can make an argument has been more progressive with regards to climate change in the United States. The first indicator of that is that in 1992, China signed on to the framework on climate change, and specifically has adopted through its Agenda 21 a series of policies and measurements to develop renewable energy. So China is very much committed to renewable energy. At least that's what the national government, the People's Congress, has stated. And then the Chinese government signed on to the Kyoto Protocol in 1998 and later ratified it in 2002. Now, of course, as many of you may know, the Kyoto Protocol does not have emissions reductions targets for developing nations, and the People's Republic of China was included on the list of developing nations. So you could look at that and say, well, yes, they signed on to the Kyoto Protocol, but it had no real implications for the country itself. So that, of course, remains a critique of China. They issued their National Climate Change Program by the State Council. So the State Council, in my understanding of government structure, is about the same level as the Premier. So the State Council is an organization that falls under the People's Congress and is a similar level to Premier Wen. And really this outlines some objectives and basic principles with regards to climate change through this year. And it was really their first comprehensive policy document responding to climate change. They also formed a group to address climate change in particular and named the Premier as the director of that organization. They've launched a call for energy conservation and elimination of pollutant discharge. And you will hear, if you talk to, or at least in my experiences talking to many individual Chinese, they are aware of the climate change initiatives, and again, they're aware of this call from the part of the national government to conserve energy. Now, whether or not that's translating into an on-the-ground change, we'll talk about in one moment. They formed the National Energy Administration in 2008. In 2009, the People's Congress released a decision specifically calling on the People's Republic of China to address climate change. And most recently, at the beginning of this year, we had another commission that was formed to address climate change. And again, Premier Wen was named as its director. So you look at that in totality, and what I came away with when I was working in Beijing for the first week of my fellowship time in China is, okay, this is pretty impressive. There's a body of law here, there's been development, there's been some indication of a commitment. Maybe what I've been hearing is wrong, and maybe we can move forward. We've got some environmental laws that we could potentially hang our hat on, and we have a commitment on the part of the People's Congress to specifically addressing climate change. So let's go. Well, what happened is there's some roadblocks. And I really experienced those roadblocks when I went to work for the following 3 weeks in a Tibetan village north of Pingwu, which is a small town of only 34,000 in China. And just by way of overview to introduce you to Pingwu, the overwhelming majority of the community's income about 5 years ago was specifically related to livestock. So a lot of cattle in this region, a lot of goats, a lot of chickens, various livestock was the primary income for the communities. But what's happened very recently, just even with the past couple of years, is that this community is facing an overwhelming amount of impacts from climate change. And in particular, this particular indigenous community is facing increased temperature overall, so it's getting hotter. I can attest to the fact it was very hot while I was there this summer, which is leading to increased water temperature, which has numerous negative impacts on the aquatic environment and the water quality as a result of the water increasing. And also at the same time, they're experiencing decreased precipitation during the summer months and decreased snowfall and snowpack. And like our western states here in the United States, which rely on their snowpack for annual water, so too does this Tibetan village. And as a result, not only is the water quality decreasing, but the amount of water itself is decreasing, which is leading to numerous problems for this community that it has recognized. And many of you, these are very similar problems that are facing our indigenous communities here in the United States and facing our indigenous communities around the world. And one of the reasons I wanted to talk about these two case studies is because I think it's really important to look at the impacts of climate change on indigenous communities because, as the title of my presentation indicated, we're really the miner's canary. We are the most vulnerable populations. We are in extreme locations throughout the world, and so we are the first to experience the impacts of climate change. And so that's why I find it very valuable to look at how these indigenous communities, what are the effects that they're experiencing, and how are they addressing those particular effects. So just so you know where Pingwu is, we have the larger white colored map there is a map of Sichuan province, where Pingwu is located. And then if you look down in the lower right-hand corner there, that red dot is roughly where Pingwu is. The village I was working with was about 50 kilometers north of Pingwu, the Tibetan village. And so the reason I was able to work with this village, as many of you may be aware, it's very difficult to go into Tibet itself. But because Sichuan province is really on what is considered to be the western border of China, even though it looks like it's in the middle, here we're talking about the Tibetan areas, and it's very difficult, as some of you may know, very difficult to travel in Tibet itself. You have to get a permit to go into Lhasa, and then if you want to leave to work with any community outside of Lhasa, you have to get another permit to leave to work with that community. So because of the travel restrictions, it was really difficult to do this work in Tibet itself, so that's why we were working with the Tibetan village outside of Tibet. But that gives you a little bit of an idea of where this community was. And just so you have an idea of what it looks like, it's a mountainous area, and you can actually see the headwaters of their stream in this picture. But I was quite surprised that they could have as much livestock as they did in this mountainous region. But it's a difficult terrain, somewhat, to deal with, but beautiful nonetheless in the area that we were working. This is one of the villagers that we were working with here, and just to give you an idea of the size of the typical home and what the community homes actually look like. So, I said there was an obstacle. I wanted to give you the context of Chinese environmental law and Chinese commitment at the national level to climate change to really make this obstacle, or at least the obstacle when I discovered it, profound. So you have these numerous environmental laws in place. There are several environmental laws. There are several statements from the People's Congress saying we are committed to climate change. Yet, at the local level, very, very little, if anything, seems to be happening. And the reason why we encounter talking to some local government officials is, first of all, there appears to be a big disconnect between local government officials and the national government officials. And even though, at least when I came to China this summer, I had this concept of a very powerful national government. And I think it is a powerful national government, but it doesn't seem to have much control over the local government officials. So the local government officials seem to be very much focused on ensuring that their community was bringing in as much revenue as possible. And there's this real perception that coming into compliance with any environmental law, climate change related or other, would cause the revenue of the community to decrease, and so therefore there was a lack of willingness on the part of the local officials to actually enforce the environmental laws. So the community that I was working with, this Tibetan village, was very frustrated because a couple of years ago they started to experience these profound impacts of climate change that were really, in particular, affecting their water quality. And they had no recourse to be able to deal with upstream users or perhaps air quality, air emissions that were going into the water. They had no recourse because the local government officials were unwilling to work with them under the local laws. And the other thing that's important here that's different between China and the United States is that the judiciary is not independent. So just like a lot of our local Chinese officials are unwilling or uninterested, at least in my experience in my discussions this summer, in enforcing those environmental laws, so too was there a lack of willingness on the part of the individual judges to enforce the laws. So this was really creating a problem for the village that I was working with as far as dealing with the environmental problems that they were facing. So it was a real obstacle. And this was the solution that they came up with that I thought was really interesting and creative on their part, is they relied on contract law. Because there's a wide body of contract law, very similar to contract law that we had here in the United States. And the Tibetan village developed an MOU, a Memorandum of Understanding, between the community members, the local government, in particular Department of Forestry, which owns the land, as we said earlier, and then a nonprofit organization, in this case it was Shanshui, for conservation easements. You may say, well, why do we want to do conservation easements? So instead of raising livestock, this community has now changed to honey production. And they're using their conservation easements along the waterway in order to have bees. And bees love it there. They love these mountains. They're flying all over. And it's been highly effective. And it's wonderful for the environment because although it hasn't reduced their problems completely, they still have a problem with temperature increase. But they are improving the quality of their water because with their livestock they had a lot of problems with sediment and various other pollutants getting into the water, fecal matter, etc., getting into the water because of the livestock. So by removing the livestock from the water, they have increased the quality of their water, or improved the quality of their water. At the same time, the honey production has generated massive revenues for this community. Marriott, while I was there in the village, I noticed this tall Caucasian gentleman with blonde hair come strolling in with a German accent, and I said, "Who is that?" And it was the representative from Marriott International Hotels there to buy their honey. So Marriott can say that it has honey from Tibetan villages grown in a sustainable manner from China in its hotels. So it's been really a wonderful win-win for the community. Now again, still the problem of temperature increase exists, and the community will have to deal with that. But as far as this water quality, we've seen an improvement. There's a very visual, and I tried to find a picture for you, and I apologize I couldn't track down the picture. But there's this great visual of when you're going down the mountainside and leaving this village. You follow the stream out of the village, and it's crystal clear throughout as you follow it. And then when you get to the base of the mountain, it hits the main tributary for the Yellow River, and it's brown. And you have this blue water coming into this sludge and mixing. And it's just a really salient, real-world example of how at least one Indigenous community has been a little creative in using contract law and the MOU to come to terms with the impact of climate change in its specific environment. Now, because of the nuances, because of those obstacles, the break between the national government and the local officials and the local judges, we didn't see much opportunity this summer for an incorporation of arguments based on the declaration. One of the reasons why is because also in China, not only do you have the lack of an independent judiciary, you also have failure on the part of most courts to recognize standing of nonprofit organizations. So unlike the United States where you have a Sierra Club or an NRDC or a NARF who could bring claims on behalf of its clients, you don't have that opportunity. So that's really limited the opportunities and avenues for creative litigation and different types of arguments in the actual courts. But I think it's a nice comparison point on how domestic law can be used to address what is becoming a big problem for our Indigenous communities, again, around the world, because many of our communities are, again, in the most vulnerable regions of the world. So now let's compare the experience of the Tibetan village in the People's Republic of China with what's happening here in the United States. In particular, I've chosen the native village of Kivalina. Some of you may be aware of the fact that this is a village which is located in Alaska, and it has approximately 400 people. It's located on the tip of a 6-mile barrier reef and is 70 miles north of the Arctic Circle. So as we heard some reference to earlier today, really the Arctic communities are some of our Indigenous communities that are facing the most drastic implications today of climate change, and Kivalina is no exception. Just so you have some idea visually of where Kivalina is located, here we have a map showing you that it's pretty far along the coast, again, north of the Arctic Circle. And here's a picture of Kivalina. And here's what's happening to the shoreline. I read research which says that in some of our native village communities in Alaska, they're losing shoreline at a rate of greater than 20 feet per year. So these shorelines are dramatically eroding. And here in Kivalina, we see that there's some effort to try to shore up the shoreline because what's happened there is the sea ice has melted because of the increased temperature. So too is Kivalina experiencing the increased temperature just like we saw in the Tibetan village. and the result has been the melting of the sea ice, and the sea ice is what protected the village from coastal erosion. And as a result, the coast of Kivalina is literally falling into the sea. And as a result, Kivalina has chosen to go to the courts. So again, we're looking today at domestic options that are available to our Indigenous communities when combating climate change. And Kivalina chose to go into the federal courts, specifically bringing its claim first in the Northern District of California. And it named all of the defendants on the right-hand side of the slide there. So this is all private industry, and the assertion of Kivalina is that these defendants contribute to global warming through their emissions of large quantities of greenhouse gases. And in particular, that these defendants include some of the largest emitters of greenhouse gases in the United States. So that is how Kivalina specifically decided on who to sue. And the injury that's alleged here is, again, that the defendants are significant contributors to greenhouse gases, that greenhouse gases trap heat, therefore causing climate change, causing a rise in temperature, and that this climate change is destroying, literally destroying Kivalina, that it's falling into the sea. And we're having massive erosion and also increased storm damage. I thought this quote here from the actual complaint filed in the Northern District was rather poignant. Houses and buildings are in imminent danger of falling into the sea as the village is battered by storms and its ground crumbles from underneath it. So literally, again, falling into the sea. What do we do as a community? Kivalina here has chosen to fall on the courts and to sue. And the element of the claim that interests me is an argument for damages based on the federal common law of public nuisance. And this is Kivalina's claim that defendants' emissions of carbon dioxide and other greenhouse gases by contributing to global warming constitute a substantial and unreasonable interference with public rights, including the rights to use and enjoy public and private property in Kivalina. So it's an interesting use of federal common law. There are also state law claims in the alternative. Kivalina argues that there's a private and public nuisance based on state law. It also argues, interestingly, civil conspiracy and concert of action. However, I just wanted you to make aware that those are there, not necessarily, we won't focus on them for today's presentation. So the Northern District of California issued its decision and found against Kivalina. Found that Kivalina's argument was precluded under the political question doctrine and also precluded because plaintiffs lack Article III standing and are not entitled special solicitude. So the political question doctrine, essentially the court says there are too many policy decisions here wrapped up in climate change. This is better served by the political branches of government, either the president or Congress. So therefore we, or this court, will not entertain the claim. Interestingly, and I'd like to focus on the standing argument here, because for those of you who are familiar with the Massachusetts versus EPA claim, you know that states have successfully brought claims, have at least successfully asserted standing in the context of climate change in front of the Supreme Court, the U.S. Supreme Court. And the reason being this idea that states have special solicitude. So, and the theory of that is that states have special solicitude or a lower standing threshold because they are quasi-sovereigns. What are tribes? I think we can make a pretty good argument that we too are quasi-sovereign governmental organizations. And the Northern District of California considered that argument in one sentence. She said in her decision, tribes are not states, and therefore special solicitude does not apply. Full stop. And I think she erred in that regard. In her analysis, certainly states are not, or tribes are not states, but the theory underlying special solicitude, I think, applies equally to tribes. So when we're looking at these domestic claims, when we're looking at our Indigenous communities here in the United States who choose to go into the courts, and this might be a viable option until we have cohesive federal action, I think we need to reconsider the standing precedent, and also we need to consider environmental justice. Now, both of these claims parallel the UN Declaration. So when we talk about standing precedent, I think we need to specifically be looking at the UN Declaration in terms of the right to self-determination that we talked about this morning, and also the right to land is quite crucial. And then furthermore, we can take these into consideration when we look at the failure of the court systems to date to consider environmental justice. I think I'm running out of time. How much time? Okay, so I'll go through it fairly quickly, but just by way of background, when we look at whether or not a tribe has special standing or special solicitude, we need to consider the Pren's Patre I doctrine, and specifically we need to look at SNAP. And in SNAP, the U.S. Supreme Court articulated the test for this type of standing and said that to have standing, the state must articulate an interest apart from the interests of private parties, so more than a nominal party, must express a quasi-sovereign interest, and must have alleged injury to a sufficiently substantial segment of its population. I looked at that, and I think, sounds like Kivalina. I think we can make an argument there that the village of Kivalina can probably meet that test. And furthermore, the SNAP court goes on to identify what are sovereign interests and says, one, protecting the health and well-being of its residents. So I focused on that and said, there again, I think our indigenous community here at the village of Kivalina, who's trying to protect its residents when the land is falling into the sea, probably has an interest there. Moreover, the SNAP court suggests that there's an interest when you're losing your property. It's happening in Kivalina. Also, the SNAP court says you have special solicitude states in standing because the federal government undertook an obligation to protect quasi-sovereigns when they came into the bosom of the federal government. Now, with a note to Mr. Coulter, and I thought his really wonderful, poignant point earlier this morning about the federal trust relationship, so a caveat there. But with the existing federal trust relationship, at least as it's articulated by the courts, it sounds like there's a quasi-relationship where the federal government has taken tribes into its bosom. So there, too, I think that the SNAP test can apply. And also, I think we need to take this in light of the UN Declaration, Article 26. Right? We have a sovereign interest in property, and the Declaration recognizes at 26 and 28 that indigenous populations have an interest and a right in the land. So there, too, we can buttress and build our domestic law claims with the UN Declaration. I think there's an opportunity for there. So as I just articulated, for me, I think the Pren's Patre I doctrine of standing or special solicitude should apply to tribes, allowing them access to the courts, that these types of claims should not be denied on standing grounds. Furthermore, I think we need to take into consideration, or the courts need to take into consideration, environmental justice. Just by way of brief definition, what I mean by environmental justice is that modern environmental justice concerns are those concerns facing communities of color, and that is the term used by the environmental justice movement, and also poor communities, where there's a disproportionate impact of environmental harm on those communities. That has been expanded out into the climate justice movement, and Mr. Berger talked about that earlier this morning in his presentation, and the involvement of indigenous communities in the climate justice movement internationally. So, how does environmental justice play in? Environmental justice principles tell us that tribes are environmental justice communities, and therefore we should consider environmental justice when bringing claims, but our claims are a little bit different than other environmental justice claims. That being because of the special political relationship that we have with the federal government, this idea that sovereignty is inherent in our tribal nations, and also because of our unique connection and status with the land. Now, if you look at those 4 bullet points on that page, they mirror closely our discussion that we had this morning of the principles articulated in the UN Declaration. So there again, we see a close mirrored relationship between the environmental justice movement, which is our local domestic law, and how we can use and mirror and correlate and build on the UN Declaration. We see a lot of mirroring between the principles of the two. So essentially the argument here is that Kivalina and our indigenous communities in the United States are being disproportionately impacted by climate change. They contribute very, very little to climate change, if anything. The native populations here in the United States, the carbon footprint is minimal. But yet our communities are the ones who are falling into the sea. And essentially that's unfair. And so therefore, when we go to the courts, we need to consider environmental justice. We need to consider the fact that tribes are separate sovereigns, have a government-to-government relationship with the federal government, and we also really need, and I didn't have much time to expand upon this last point, but we need to consider that unique relationship. I love Mr. Berger's story that he told this morning about the Indigenous representative in Geneva who's talking about his unique spiritual connection with the land. That is something truly important about our communities, about our Indigenous communities. And so therefore we need to take that into consideration when we're looking at these claims in the courts, and in particular we can take that into consideration through an environmental justice lens. So therefore, reconsideration of Kivalina's claims is warranted. This claim is currently pending in front of the Ninth Circuit Court of Appeals. Has not yet been heard on oral argument. But when we reconsider that, we need to look at how the Declaration mirrors our domestic law, and in particular, I think we can use the Declaration to buttress arguments that one, Kivalina and similarly situated Indigenous communities have standing under the Parens Patriae doctrine for special solicitude, and we can use the elements of the Declaration to make that point. And furthermore, that these types of claims need to be specifically considered by the court through a lens of environmental justice. Again, remember that PowerPoint 2 slides ago where the 4 aspects of environmental justice in Indian country specifically are mirroring the important aspects of the Declaration that we talked about this morning. So I think we have a very close relationship there between the domestic law of the United States and the Declaration. Unfortunately, we're not seeing a close relationship like that yet in the People's Republic of China, but what I walked away from this summer is that our Indigenous communities in China are interested, they're active, they're thinking creatively. So hopefully I'm going to continue the optimism of Mr. Echohawk, as he said this afternoon, and hopefully we'll get there eventually in the People's Republic of China, but I think we have a real opportunity to do so here, at least with our consideration of these types of arguments in claims like the native village of Kivalina. So thank you, Che Miigwech.